If someone close to you has passed away without a will, you're probably trying to figure out what to do next. What does the family have a right to? Who decides how things will be distributed? And what is the first step that you need to take? These are all the right questions. I am Asthana at Southern Estate Lawyers. We help Alabama families navigate intestate succession, the legal process that takes over when someone dies without a will. Let me walk you through how it works. When someone dies without a valid will in Alabama, they are said to have died intestate. There is no document that exists that tells anyone what needs to be done. So Alabama law steps in and decides for them. And this is called intestate succession. It applies a fixed set of rules to every situation, regardless of what the person may have wanted, regardless of the family relationships, and regardless of what anyone was told. Only the assets that the person owned in their own name are affected. Assets that have named beneficiaries, like life insurance or retirement accounts, sometimes bank accounts, pass directly to the beneficiaries named outside of this process. Alabama's intestate succession rules follow a strict order. If there is a surviving spouse with no living children or parents, the spouse inherits everything. If there is a spouse but no children, but you do have living parents, the spouse receives the first $100,000 plus half of what remains, and the parents, they receive the other half. If all of your children are also your spouse's children, your spouse receives the first $50,000 plus half of what remains, and your children split the other half. If any of your children are not your spouse's, the estate is divided equally, a half to your spouse and the other half to the children to be shared equally. If there is no living spouse, the children inherit the entire estate equally. If there is no spouse and no children, assets pass to parents, then siblings, and then more distant relatives. There are some people that receive nothing under Alabama's intestacy laws. Stepchildren are not included unless they were legally adopted. Unmarried partners receive nothing, regardless of the length of their relationship. Close friends receive nothing. And any charities or organizations the person cared about receive nothing. The only way to provide for these people is through a valid will or estate plan. And that's not the only gap. There is another gap that catches families off guard. If you have minor children and no will, Alabama law does not let you choose who raises them. It is the court that decides who will be appointed their guardian based on the court's discretion as to what's in the best interest of the children. A will is the only way to name a guardian for your minor children yourself. Without that, that choice is left entirely to a judge. When someone dies intestate in Alabama, the estate goes through probate court located in the county where the decedent was last resident of. The court appoints an administrator. Usually, it's the closest next of kin to manage the estate. That administrator is responsible for identifying and valuing the assets, notifying creditors, paying valid debts, and distributing what remains to the heirs. The administrator is typically required to post a bond, file an inventory of the assets, and also do an annual comprehensive accounting, which adds time and cost to the process. Each Alabama county has its own probate court, with its own procedures and deadlines. Having a probate attorney who understands how each of these courts operate makes a huge difference. Two questions that come up right away is how long does this take and what does it cost? On timing, most Alabama estates take about 6 to 12 months. However, intestate estates take longer. That is because there are extra procedural steps to be followed and disputes may arise. On cost, there is no single fee that fits every estate. There are court filing fees, the cost of notifying creditors, attorney's fees, accountant fees, the bond that the administrator has to post, which is an added cost which can often be avoided with a will. The total fee depends on the size and complexity of the estate. We give you a clear picture of both the time and cost at your free consultation. Let me answer a few more questions that we often get. First, does my spouse automatically get the house upon my death? The answer is not always. If you own the home jointly with right of survivorship, it will pass to your spouse automatically upon your death outside of probate. But if the house was in your name alone or was owned as tenants in common with your spouse or someone else, it becomes part of the estate and it gets administered pursuant to the intestacy laws, which can mean that your children could share ownership with your spouse. Second, is there a deadline to open probate? While it's true that there is no law requiring you to open probate within a few weeks, If the deceased person left a will, Alabama does have a strict deadline to submit the will to probate. Under Code of Alabama, Section 43-8-161, a will must be filed for probate within 5 years from the date of death. If you miss this deadline by even a day, it becomes a lot harder to open that estate. Third question is whether every estate has to go through full probate. The short answer is no. Alabama actually has a streamlined, small estate process called summary distribution. Thanks to recent updates, the threshold requirement was raised to $47,000. So if a deceased person's assets fall under that limit, and they didn't own any real estate solely in their name, you can often bypass full probate. This process is significantly faster, cheaper, and shorter than traditional probate. And another piece of Alabama law that really surprises people is that your heir has to survive you by 5 days in order to receive anything. If they don't meet this requirement, they are legally disqualified from inheriting anything, even if they were named in the will. What most people don't know is that a properly drafted will can change this. If your will includes specific language addressing simultaneous deaths, requiring an heir to survive by 30 days, 60 days, or even a single minute, the court will follow your will instead of the state's default rule. That kind of language matters in situations where multiple family members are in an accident. It's one of those details that most estate planning attorneys will think to include, details that most people will never think to ask about. Intestate estates generate more conflict than you often expect. When there is no document that outlines what the decedent wanted, family members will disagree about what's fair. Blended families are especially vulnerable in these situations. This is because the law draws a sharp line between biological children and stepchildren who are not adopted, and between legal spouses and long-term partners. These situations are hard enough without a legal fight on top of them. As Southern estate lawyers, we know how to handle these disputes early. And if it reaches the courtroom, we are already prepared to represent you. Whether you're dealing with a loved one's estate right now, or you want to make sure that your own family is never left without a plan, Southern Estate Lawyers is here to help. We have offices in Mobile, Birmingham, and Foley, and we serve families all across Alabama. Call us to schedule your free consultation, and we look forward to working for you.